and welcome to a new podcast episode of the China IP SME Help Desk. My name is Alessandra Capriglia, and today I will be discussing the amendments to the China's copyright law with our IP business advisor, Matthias Stubimendi. Hello, Matthias. Thanks for joining me.
Hi, everyone. Thanks, Alessandra, for having me today.
Before diving in, Matthias, can you share a few words on how copyrights can be an important part of an IP strategy when doing business in China?
Yes, first of all, copyright is one of the main types of IP that creative industries rely on. For example, if you are creating music, producing artwork, or relying heavily on software, copyright will be able to protect the expression of your ideas. Copyrights are automatically protected once the work is finalized, as China is part of the Berne Convention. However, registration can provide valuable proof of ownership, which is useful in settling disputes efficiently, especially in the case of infringement on e-commerce platforms. So, it is recommended to register copyright for your main artworks before somebody else does it, as bad faith registrations sadly are quite common.
Speaking of, how can copyright provide protection on e-commerce platform?
Copyright can be used to complement trademark protection in China. Having registered your logo as copyright gives you an added layer of protection, especially on e-commerce platforms. On e-commerce and online stores, copyright can also be used to stop someone else from using your product pictures, product catalogs, or instruction manuals to sell their products.
Copyright is indeed a very important IP right, often underestimated. Now, regarding the latest amendments, the revised copyright law came into force on 1st June 2021. What are the main changes in the law?
The previous amendment to the copyright law was made in 2010, so the new amendment adapts China's copyright law to the newest technological development. It also strengthens copyright enforcement and introduces higher damages compensation, which provides European companies a better sense of security.
Let's dive in a little deeper. The new copyright law left the subject matter of copyright open-ended, stating that any intellectual achievement that complies with the characteristics of works and are expressed in a certain form can be protected by copyright. What does it mean in practical terms?
In practical terms, this means that more non-traditional artistic expressions could be protected by copyright, such as the shows of water fountains, fireworks, drone choreographies, or flash mobs, for example.
Also, some terms have been changed. Can you share some examples?
Yes, indeed. For example, the term cinematographic work and works created by a process analogous to cinematography was replaced with the term audiovisual works. Furthermore, the right to broadcasting was broadened to include the right to publicly disseminate or relay a work by wired or wireless means. These changes are important as they can help preventing piracy of live stream sport events and other events, as well as protect short videos and animations.
So, does it mean that companies can also protect, for example, TikTok videos of their products in China under the new copyright law?
Yes, correct. In fact, the new copyright law aims to better protect the creative industry from digital piracy. To this end, the copyright law includes new articles that allow copyright owners to take technical measures to protect their copyrighted works. It also prohibits the circumvention or destruction of these technical measures, as well as the provision of devices or components to circumvent or destroy the technical measures taken by the copyright owner.
And what are these technical measures that SMEs can implement?
Technical measures to protect copyright from piracy could include encryption, watermarking of photos, time-sensitive password to allow access to videos, music and text or chips in games consoles that will only allow to use the console from given a geographical location, for example.
As we always emphasize, enforcement is also crucial when developing an IP strategy. What are the changes for enforcement of copyrights?
To strengthen the enforcement of copyright and deter potential future infringement, the maximum amount of damages compensation was increased considerably from 500,000 renminbi to 5 million. Furthermore, a minimum fine of 500 renminbi was also introduced.
That's indeed a considerable change. But how can you measure damages?
There was also a change in the way damages are calculated. The amount of damages can be calculated based on the actual loss suffered by the IP owner or based on the illegal gains of the infringer. It is left for the IP owner to choose which method is more preferable. Should it be too difficult to calculate the actual loss of the IP owner or the illegal gains of the infringer, it is possible to use the royalties to calculate the amount of damages. Also, the new copyright law introduced punitive damages in case of serious and willful copyright infringement, which are repeated infringement. In this case, punitive damage can be 1 to 5 times the original damage awarded.
Can you share a concrete example?
For example, someone copied your software and was ordered by court to stop the infringement, so they stopped for a while but then started to make money on your software again. The new measure is designed to stop future infringement from discouraging infringers for continue infringing activities through the introduction of very high penalties.
Another important amendment that strengthens copyright enforcement is the shift in the burden of proof in favor of the rights holder. What does it mean in practical terms?
Well, these are good news for European SMEs, as it means that the evidence they need to provide to the Chinese court is not as extensive as it used to be. It can be very difficult to obtain all the evidence, especially when you are not located in the same country. Under the new law, if the right holder is not able to provide simple evidence of infringement, the Chinese court can ask the alleged infringer to produce the accounting materials. The burden will be on the alleged infringer to prove that no infringement took place.
So the courts were also given powers to destroy the infringing copies of copyrighted products, as well as destroy the materials, tools, and equipment used to make the infringing copies. This is another measure that is designed to decrease future copyright infringements. Lastly, the new copyright law gives additional powers to the administrative copyright authorities when investigating suspected infringements. What does this amendment entail?
The authorities may now question the infringers, conduct on-site inspections, collect evidence by making copies of relevant materials, and seize the alleged infringing materials. This is another amendment that can be helpful for European SMEs who need to enforce their copyright in China. It is well known that Chinese courts only accept notarized evidence on infringement, which can be very costly for an SME to obtain. However, the evidence collected by the copyright authorities can also be used in courts without further notarization, making the process of evidence collection less difficult and less costly for the SMEs.
Great, I think we have covered it all. Many thanks, Matthias.
My pleasure.
If you want to know more about copyright protection in China, check out the link in the description. You can download our IP guide from our website for free. We welcome European SMEs to submit any copyright-related questions, as well as other intellectual property-related inquiry to our helpline address, question@china-iprhelpdesk.eu. Our IP business advisor will provide you with a free and confidential advice within 3 working days. That's all for now. Thank you for listening and stay tuned for our next episode.